Welcome to Imagine IP. Today we're discussing the Federal Court of Australia decision in Sanofi v. Amgen Inc. This appeal concerned 5 patent applications by Amgen for isolated monoclonal antibodies that target PCSK9, a protein involved in cholesterol regulation. PCSK9 degrades LDL receptors in the liver, so blocking it could help reduce bad cholesterol levels. Sanofi opposed these applications on multiple grounds, arguing they would be clearly invalid if granted. These antibodies represent a potentially major advance in treating cardiovascular disease, one of the leading causes of death globally. You can think of LDL receptors as vacuum cleaners in your liver that suck up bad cholesterol from your blood. PCSK9 is like a vandal that breaks those vacuum cleaners. Amgen's invention is essentially antibodies, your body's security guards, that can catch and stop this vandal, allowing the vacuum cleaners to keep working and reduce cholesterol levels. This was an opposition case rather than an infringement case. Sanofi was trying to prevent these patents from being granted in the first place, rather than challenging them after grant. This meant they had to show the patents would be clearly invalid, a high bar requiring convincing evidence across multiple grounds. To further understand this case, I'm joined by representatives from both Sanofi, Amgen, and Justice Nicholas, who decided the case. Let's hear from Sanofi first. What were your main objections to these patent applications?
We had fundamental concerns about these applications on 6 key grounds. First, failure to define the invention. The claims don't actually define any specific antibody structure. They just describe functional outcomes, any antibody that blocks PCSK9 binding to LDLR. As we argued, the claims do not elucidate the amino acid sequence, i.e. the structure, of any antibody. Without knowing the actual structure, how can you know if you're infringing before you make the antibody? Second, these aren't proper subject matter for patents. They're just abstract ideas, or mere desiderata, wishful thinking about antibodies that might work, not actual inventions. Third, lack of fair basis. The specification really only describes 3 specific antibodies, 21B12, 31H4, and perhaps 16F12, but the claims cover hundreds, if not thousands or many more antibodies. This travels well beyond what's actually disclosed. Fourth, the competition claims lack clarity. They don't specify what degree of competition is required, and different assays can give different results. Fifth, obviousness. Professor Horton's evidence showed that by 2007, the literature had conclusively demonstrated PCSK9's extracellular pathway, making antibody approaches obvious to try. Finally, insufficient description. Each claim covers multiple different inventions that aren't fully described.
Amgen, how do you respond to these challenges?
We fundamentally disagree with Sanofi's characterization. On claim definition, our claims properly define a class of antibodies by their functional characteristics. The law has long recognized that you can define inventions by the results they achieve, especially when that's the only practical way to characterize them. As established in cases like Millard, it is permissible in a proper case to define the physical characteristics of the article by a suitable reference to the results which it is to achieve. On patentable subject matter, these aren't abstract ideas. They're physical molecules, specific antibodies that can be made and tested. They have clear therapeutic utility and economic value. On fair basis, the specification describes a class of antibodies that bind to particular epitopes, comprising specific residues on PCSK9. Our consistory clauses clearly describe this invention, and examples 28-30 identify the relevant residues through crystallographic analysis. The specification states that antigen-binding proteins that interact with any of these PCSK9 residues can be useful as antibodies that inhibit the interaction between PCSK9 and the EGFA domain of LDLR. On clarity, the skilled person would understand competes and could readily perform competition assays to determine if antibodies fall within our claims. On obviousness, Sanofi ignores the significant uncertainties that existed in 2007. Dr. Parker's evidence showed it wasn't clear whether PCSK9 functioned primarily intracellularly or extracellularly. For antibodies to work, PCSK9 needed to function at least 50% extracellularly, which wasn't established. Many experts, including Professor Hudson, testified that generating effective antibodies would have been very challenging without our disclosure.
How did the court analyze these competing arguments?
We had to carefully consider each ground of invalidity. applying the standard that Sanofi needed to show the patents would be clearly invalid if granted. We found the key issue was whether claims defined by functional limitations can adequately characterize antibodies. Following Mallard and Interlego, we concluded that defining articles by their functional results is permissible when sufficient to characterize the construction of the article claimed. The skilled addressee can determine whether any particular antibody falls within the claims through routine testing, even if they can't predict this in advance of making the antibody. On manner of manufacture, these claims are to physical, chemical compounds with established therapeutic utility, not mere abstract ideas. Unlike cases involving information or computer methods, these antibodies are tangible molecules produced through human action on fair basis. This was complex, but we found the specification adequately discloses the claimed invention. The consistory clauses describe antibodies that bind to epitopes comprising particular residues, and examples 28 to 30 identify these residues through crystallographic analysis of interaction interfaces. The specification explains that antibodies that interact with or block any of these residues can be useful for inhibition. On obviousness, this was perhaps the most challenging issue. While Lagos 2006 suggested antibodies can be explored, this was highly qualified, stating that success would depend on PCSK9 functioning as a secreted factor. Dr. Parker's evidence was particularly persuasive. Even at BMS, with significant resources, they didn't pursue antibodies because the pathway wasn't clear. Professor Hudson testified that chances of success would be pretty low without the specification's teachings. On clarity and sufficiency, we found no clear invalidity on these grounds either.
Let me summarize the key learnings from this decision. Functional limitations can validly define inventions, especially in biotechnology where structural characterization may be impractical. However, ensure the limitations are sufficient to characterize the construction of the article claimed. When drafting claims for complex biologics, include functional limitations that clearly distinguish your invention from the prior art, but ensure the specification provides adequate guidance for determining infringement. Broad claims can be fairly based on more limited examples if the specification adequately describes the broader class. The court will look at consistory clauses and supporting examples to determine if claims travel beyond the matter disclosed. Ensure your specification includes clear statements describing the invention as a class, not just individual examples. Use crystallographic data, binding studies, and functional analysis to support broader claims. Even where prior art suggests a general approach, significant technical uncertainties can support non-obviousness. Industry practice and expert testimony about real-world decision-making carries significant weight. Document the technical challenges and uncertainties your inventors faced. Gather evidence of how skilled teams actually approached similar problems, not just what academic papers suggested might be possible. Claims defining antibodies by competition with reference antibodies can be sufficiently clear if the specification provides adequate guidance on testing methodologies, even without specifying numerical thresholds. When using competition-based claims, ensure your specification describes multiple suitable assay methods and explains that any detectable competition satisfies the claim. This case shows how opponents may raise multiple invalidity grounds simultaneously. The clearly invalid standard in oppositions requires strong evidence across all grounds. When facing opposition proceedings, prepare comprehensive evidence addressing each ground. Focus on expert testimony about real-world technical challenges and industry practice, not just academic possibilities. This Australian decision provides insights for similar patents in other jurisdictions, particularly regarding functional claiming in biotechnology and obviousness analysis in uncertain technical fields. This decision reinforces that well-drafted biotechnology patents with adequate disclosure can withstand broad validity challenges, even in competitive pharmaceutical layers. The key is ensuring your specification tells a complete story about both what you've discovered and why it was non-obvious to discover. That's a wrap on today's analysis of this significant decision. We are likely to see more decisions in this space, so stay tuned, and as always, keep imagining.